as you have undoubtedly heard, if you've been following us at all, our emails, our social media posts, our webinars, there are things happening in the world of Medicaid. And I've been talking about them for many, many times over the last, we're at 14 months since the governor signed the law. And today we're here, we do have final updates as to what's going on as far as implementation. I'll be talking about that, but we're here to share that we have months left to plan, to protect, and to actually apply before the community Medicaid benefits change, before we have the implementation of the new law. And I'll be getting into that a little bit today. All right, so people are still blinking here. Let me see what people are saying. Very good. Okay, good, great. So let's get started. Now, as I start all of my elder care based webinars, for those that are new, and we do have many new people because we're doing this at a new time slot of 7 o'clock, I always like to give the overview as to what we're talking about and why it's important. All right, so bear with me if you've seen this before, but it's important for everybody to realize that certain things exist that make planning, protection, and applying a reality. And the main part is this fact that as we get older, we have different things occur. Different issues present themselves. They can be medical in nature, for example. You go to a doctor, you go to a hospital, a rehabilitation center, that's medical. Your health insurance will be paying for that type of short-term care. Medicare, if you have that, will be paying, and hopefully they're paying as much as possible. On the other side of that coin, though, there are needs and things that can occur to us that are not necessarily medical in nature, and therefore our health insurance, our Medicare, is not paying. Those are called long-term care. That is called long-term care. And that is best defined by our functional abilities, all right? The ADLs, those activities of daily living, those are our functional abilities. And when we can't perform our ADLs, then that is when we need long-term care assistance. Our activities of daily living are, there's a couple different types of lists, but everybody can agree, transferring is an ADL. Transferring is the act of getting out of a chair or getting off of a bed. Walking is an ADL. Bathing, toileting, dressing, grooming, and eating. Those are the ADLs that we focus on in the context of long-term care. Now, that's literally everything you did in the morning, right? You got out of bed, you walked to the bathroom, you used the bathroom, you bathed, showered, you got dressed, you combed your hair, and you ate. If you can't do some of those, then again, you're going to perhaps be better off with some type of assistance, all right? Now, why is paying for long-term care at home an issue? So in order to get assistance, and just like everything else in this world, you have to pay for it. To pay for long-term care in your home, which is what we're focusing on tonight, you could also receive long-term care in an assisted living. You can also receive long-term care in a nursing home, of course, but we're focusing on home care. The vast, vast majority of clients wish to stay home in their own home if possible. So why is paying for long-term care such an issue? One reason, it's expensive, all right? Home care can be billed hourly, it can be billed daily, it can be billed monthly, and then we can look at it on an annual level. 25 to 30 bucks is what you're looking at on an hourly, which can equate to about $300–400 a day, which can add it up for the month. You could be looking at about $10,000 to $11,000 a month for home care on the extreme side, on the significant amount of hours per day. And then annually, it's just ridiculous. For home care, you're over $100,000, $130,000, $140,000. Nursing homes are nearly double. Okay, so again, focusing on home care today, the costs for long-term care increase greatly, and they can run through a person's life savings before they realize it. So how do we actually pay for long-term care? Well, as I was just sharing, you can use your cash, you can use your life savings, you can use your retirement money, which we don't generally recommend, but you can use your own money to pay for it. And the problem with that is it's finite and you can spend it all. You can use long-term care insurance if you actually have long-term care insurance. That's point one. Point two about long-term care insurance is the policy sufficient? I've sat with many, many clients that say, I have long-term care insurance, but then when we look at the actual policy, I'm glad they have it, but when we actually look at the policy, the daily benefit can be $80 a day for home care or $250 a day for nursing home care. When you look at the numbers we just spoke about, $300-400 a day for home care, $600-700 a day for nursing home care, $100 or $200 a day doesn't cut it. So the reality of having a long-term care policy is not a panacea. It doesn't solve all the problems. It depends on what the actual benefits are going to be. Now, the third way to pay for long-term care in your home is what's called community Medicaid. Most, if not all of you, have heard that. That is the program where New York State, upon eligibility, will send an aide in for a certain amount of hours to assist with those ADLs, all right? Community Medicaid is a godsend of a program, and we do all we can to help people to utilize this program appropriately, to get as much as they can out of it, and really help them get the best care possible. So, Community Medicaid, that's the focus of tonight. Now, what does Community Medicaid actually provide? Well, as I just mentioned, they'll provide that aid to come into the home to help with those activities of daily living. They provide some case management on a higher level. They can provide transport. They can provide adult daycare, all right? Very valuable. Hasn't happened in a year because of the pandemic, but hopefully they'll be opening up again this summer. They can supply, help with supplies such as incontinence supplies, and also podiatry, audiology, and dental. The Community Medicaid program, as we have it today in the last 6-7 years, is what's called an MLTC. It is a managed long-term care program, and these are the benefits that all come within that. Now, eligibility for Medicaid, what I should say is Medicaid does not happen overnight. The Medicaid application process is a cumbersome endeavor. Not only is it fraught with risks, and if mistakes occur, it can cost the family thousands of dollars. It can cause delays in receiving the care, which can be even more dangerous as far as money and not having the appropriate care in the house. So the Medicaid application process is generally, and it's funny, I tell people like it is. I'll tell somebody Medicaid is 5 to 6 months long before you get the aid in the house. And probably once a week, I'll have a potential client say to me, wait a minute, another attorney told me it takes 2 months. Okay, well, it depends when you start counting the time. I like expectations to be set based on reality. The 5 to 6 month window starts when we're engaged and ends when you actually have an aid in the home. When somebody says that Medicaid is a 2-month process, that's after the person is made eligible financially. That is after all of the documentation is gathered. That is after the Medicaid application is assembled and filed. Once it's filed with the county, now you've got 2 months. All right. So I can say Medicaid application is 2 months, but it takes a month or two to get to that point. And then once the determination get to the end of that legal and financial application, then you begin the third segment of Medicaid applications, which is the care aspect. That's the assessments. That's going to be New York State sending in 2 different nurses to evaluate whether long-term care is needed. And then the MLTC is in there to determine how many hours they're going to pay for. That's another month or two. All right. So the process can be cumbersome. It can be time consuming. It can be difficult. And it's risky. Now, as I share with clients, there are 3 aspects to Medicaid eligibility. All right. It is the applicant's assets, it is their income, and it is their care level. Real brief. And by the way, if you want more detail on this, our website, tullyelderlaw.com, under the video tab in the navigation bar, we'll have a webinar section. You'll have all of our webinars for the past year plus. And we get into irrevocable trusts, we get into planning, we get into nursing facility care, we talk about crisis and the eligibility factors when it comes to Medicaid. So I like to keep these webinars short because people have lives, they've got kids, they've got parents, they've got spouses, they've got homework, they've got real work. So I only spend about 30, 45 minutes covering these issues. If you want more depth, then certainly check out the other webinars on the site or shoot me an email as to what you want to see. All right, Brian@Tully Elder Law is the email, and I can craft a new webinar answering your question if it's appropriate for the audience. Again, Medicaid eligibility, 3 things: assets, income, and care. On the asset side, an applicant can have $15,900. That is not monthly, that is not annual, that is not income, that is the assets in the bank. That includes checking, savings, CDs, money market, investments, stocks, bonds, non-qualified annuities, life insurance, cash value, second homes, etc. $15,000, I like round numbers, $15,000 is the maximum an applicant can have. We always like our clients to be between $5,000 and $10,000. I don't like them to get too close to the $15,000 number. It's just too risky if something, a check hits. In addition to the 15, an applicant can have their retirement accounts, IRAs, 401ks, qualified annuities, all right, provided they are in payout status, okay? You hit 72, you start your required minimum distributions. That's what I'm talking about. Once you have your RMDs being taken every year, or you force it into payout status if you're younger, then that retirement account is exempt and can be kept in addition to the 15 grand, all right? On the income side, just as shocking, $904. That is what an applicant is allowed to have when they're applying for, again, home care. Now, most folks have an income greater than $904, and they can have Social Security, they can have a pension, they can have interest, dividends, retirement distributions, right? So that whole number comes into play. On the next couple of slides, I'll talk more about this as well as asset strategies. But that's what we're looking at as far as dollars and cents. Now, on the care side, it comes down to those activities of daily living. The more help that is required, the greater the hours. Generally speaking, there is a 2 ADL requirement under current law for there to be an approval and an award of hours. When the new law ultimately comes out, and again, other webinars on our website talk about this, tullyelderlaw.com, when the new law comes out, they're actually pushing it up to what's called physical maneuvering with 3 ADLs. So it's going to be harder on the care side next year, as well as what I'm going to be talking about, which is the legal and the financial, okay? Now, to dig a little deeper into this, on the asset, income, and care side, specifically on the asset side, how do we protect our assets to become eligible? How do we get down to that $15,000 number? And the reality is, under current community Medicaid benefit rules, there is no look-back period and there are no penalties. What that means is New York has been very fortunate over the last number of years. I have colleagues in other states that are very jealous because we can literally shelter assets in June and be eligible in July. Doesn't mean you're approved. Remember, you got 5 or 6 months for that to happen. But under current New York State community-based Medicaid benefit eligibility rules, there's no look-back period and there are no penalties. A look-back period by definition, and I'll use a nursing home scenario because that's where it exists and everybody's going to know this rule. That's the 5 years you got to worry about. If somebody applies for for Medicaid in a nursing home, you have a 5-year look-back period. That's 60 months. That means we, as the attorneys working this through, need to get from the family 5 years of financial records as well as detailed transactions, all right? Certain deposits, certain withdrawals. The purpose of the look-back period is for the Medicaid agency to literally review every page, every side of every page of every statement of every account for 60 months. What they're looking for is to see if there were any asset protection steps in the nursing home scenario. Was an irrevocable trust funded? Was money transferred to a child or a neighbor? If so, that transfer will be considered a gift and will be penalized, all right? Therefore, the purpose of a look-back period is to review the whole financial situation, look for any asset protection steps, penalize the applicant, So Medicaid doesn't have to pay for the care. That's what a look back period is all about in a nutshell. So community Medicaid, as I've said, does not have that right now. We literally can shelter assets in June again and be eligible in July. Now, how do we make somebody eligible as of right now? We utilize irrevocable trusts and we utilize gifts to the family if appropriate. So either the client, the parent, the spouse does this themselves, they engage us and we work with them, or more likely we're dealing with a spouse or a child that has a durable modified power of attorney. That is a whole nother webinar. Power or webinars, there are several on there that talk about capacity, talk about guardianship, talk about the power of attorney. The power of attorney may be the most important document when it comes to elder care and asset protection. It is only with the proper modified power of attorney where an agent can help protect assets and protect income, okay? And to make it a little more complicated, why not? New York State is actually, believe it or not, changing the entire power of attorney statute this upcoming week. Starting next Monday in office, we will have a brand new power of attorney form. It is meant to be simpler, meaning we're not signing in 3 places, initialing in 3 places. There's no gift writer. We have one form, one modification section, and it's meant to be simpler. Again, another webinar is on the website talking about that. But for the purposes of tonight, let's assume we have a power of attorney with the right modifications for asset protection and income protection, and we're going to be utilizing an irrevocable trust. Now, when the title of the webinar says it is, you got months left to protect and to apply, this is generally what we're talking about. It's this irrevocable asset protection trust. Not to spend a tremendous amount of time on it because, again, there's other resources out there on the website about this. But it's important to understand that the irrevocable asset protection trust is probably the most flexible tool that we have in our arsenal to protect assets for our clients, all right? We've been doing them for 20 years, and it is a very valuable strategy and tool that we implement. For those that may not want an irrevocable trust or be intimidated of it being irrevocable or a trust itself, it's important to realize it is nothing more than a written agreement. That's all it is. You have a grantor, which is usually the parent, the one creating it, the one granting it. You have a trustee, which is typically a child or a sibling or trusted friend. That's the manager. And then you're going to have beneficiaries. Those are the people that benefit from the trust. Typically, it's initially the parents and the children. And then after the parents, years down the road, Lord willing, are deceased, then it's the beneficiaries. Again, typically the children. So it's a written agreement between the grantor parents and the trustee. And it has a lot of different terms in it. And again, simply outlining it here, the right to live in the house. 99% of the time, we are sheltering a home, their primary residence or a second home. The irrevocable trust is a fantastic tool, very flexible tool to shelter real estate, as well as other non-retirement assets. So if we put a home in there, it's going to say, I, as the grantor, my spouse as the grantor, have the right to live in there. We can sell, we can buy, we can control who the trustee is, we can control who the beneficiaries are. What does that mean? Well, if I pick my oldest child as my trustee and years down the road, I want to sell my property, the trustee says, no, you're nuts. I'm not selling this place. I want it when you're gone. Well, that trustee just got fired, okay? I, as the grantor of my irrevocable asset protection trust, control who my trustee is so I can fire and remove anybody I wish that's serving as trustee, okay? So I keep that power. Same thing with beneficiaries. If that oldest child, this trustee, says really turns sour, the relationship falls off the rocks, I can actually disinherit them. So I can change their inheritance, I can minimize their inheritance, I can kick them out altogether, I can skip them and give it to their kids. I have all that control. So even though it's irrevocable, I've got contingencies and I've got control and I've got flexibility, all right? Now, in order to gain protection, all right, we can't have access. So we can have all the control we want, all the flexibility we want, but whatever's in that trust, it's what's called principal. I am not allowed to have access directly to that principal. The trustee cannot write me a check. The trustee cannot use that money for my benefit. That is the asset protection part. The way I share it is this. In order to actually shelter what's inside and protect it, I have to build a wall between what's inside the trust and the clients. And the way we build that wall, there's a couple different ways, but this is the biggest stone, if you will, that we use in the wall, is this one rule that I have to eliminate, minimize your access to what's inside. Now, I can still get what's inside out of the trust. We always build in a back door, and we can talk more about that. But there are ways to get funds out of the trust if it's an emergency and if it's necessary. All right. Distributions for children, for example, are going to be allowed. So there are ways to work through this scenario. Now, in addition, if you do have cash and investments within this type of a trust, again, you're not allowed the principal directly or for your benefit. But if there are interest or dividends generated, you get them. So if you're relying on interest and dividends to pay your monthly bills, and that's why you want to keep that investment account in your name, you can still put it in a trust like this and still get the interest and dividends, okay? There are more points, of course, about it and 100 questions. Oh, by the way, if you have questions, put it in the chat, put it in the Q&A box. I'll answer them when we're done, okay? Assuming we have time. Now, the next part of community eligibility after the assets is income. And again, $904 a month. Well, what if I have more than $904? Well, we use, again, thank God we have something like this. It's what's called a pooled, P-O-O-L-E-D, supplemental needs trust, also called a pooled income trust. Pooled income trust is a bit easier to say, so I usually use that. What is a pooled income trust? Well, it is, I got a slide on this. Hold on a second. All right, a pooled income trust, pooled supplemental needs trust, is established by a charity, a nonprofit in New York State. That's how the law works. That's how we're able to shelter income in New York when a loved one needs home care. And the way it works, I give five points generally when I'm talking to clients. And it is mechanics. All of the income hits the client's account, your parent's account, just like it does normally. They're allowed to keep their $900. They're also allowed to keep any health insurance premiums, by the way. And then on top of that, whatever's left is called the overage. That gets swept, hopefully automatically, every single month into your pooled income trust account. There will be a monthly fee for what they're doing. All right, they're entitled to get paid for what they're doing. They're going to be paying bills. And the second point is their job is to then pay the bills of the Medicaid recipients, that are in their name. They're not paying spouses' bills. They're not paying kids' bills. If you have a mortgage in your name, they'll pay it. Real estate taxes, homeowners insurance, credit card bills for current charges for the applicant, utility bills, etc. They're there to pay bills. The goal of this type of an income trust is to spend every single penny on the living expenses, all right? Not the medical expenses. They're not there to pay co-pays. They're not there to pay premiums. Why? Because you can keep the premium. They're not there to pay deductibles, all right? They're there for living expenses. Then the way I share it is use it or lose it. If we have a $2,000 monthly overage, and I know I'm speaking fast, and of course you can ask questions, and if it's best, if you have a particular situation and you actually want to meet with me on this, we can do that too. We offer free consultations to cover these issues. Now, use it or lose it. So let's say there's a $3,000 income. $900 is what they're allowed to keep. Let's assume there's no health insurance premiums. $2,100 is the difference. That is the overage. Every month that hits the pooled income trust account, they'll take their fee. For round numbers, let's say that's $100. Now we've got $2,000 left. You want to spend every penny. If you can't spend every penny, let's say you can only spend $1,500, $500 will then roll over to the next month under current law. And same thing happens next month. Now you've got $1,000 rolling over to the third month. That money is still able to be used under current law for the Medicaid recipient, for your loved one. You have a roof repair, you got a car problem, change the windows in the house, prepay funeral expenses, pay the accountant, pay legal fees. You can use that money while your loved one is still with us. The lose it part under current law is that once they do ultimately pass on, whatever's left in that account is lost, okay? Something to be mindful of. It does not go to us. It doesn't go to the family. It goes to the underlying charity. Okay. Now, the new law might actually be changing that rollover. They're trying to. We don't know yet how it's going to happen, but when the new law is implemented, which I'll be talking about shortly, New York State has said if there's an overage and you have any money left over you're not spending, they're going to take it or penalize it. There's a tremendous pushback on that provision, and we're hopeful it won't happen as written. And we're only going to know as this evolves and develops over the next several months. Okay. Now, still talking about current eligibility for Medicaid on the care side. Okay. Because again, Medicaid is not just about assets. It's not just about income. It's not just about what you have to protect financially. It's about what are your care needs. And by the way, this is the most important part for me. This is why we do what we do. Yes, it's nice to shelter assets. Yes, it's nice to protect income. But what we do is, and the way we provide our services is to help your loved one get the best care possible. If we cannot help your loved one get the best care possible, what is this all for? To me, it's not. There are plenty of attorneys that will protect the house and do the Medicaid work. If that's all you want to do, then we may not be the best firm for you. If the care of your loved one is just as important as protecting the assets and income, then we are the place to help. All right. And so let me talk about that. How do we get enough hours approved? All right. And generally speaking, that correlates to quality of care as far as you have somebody in the house to help with more hours. Of course, family needs to be involved. Of course, our advocates are involved, which I'm going to talk about right now. We on staff have very uniquely what's called elder care coordinators. Our business, our practice model is to help families with something called life care planning. We do the legal work, we do the financial work, we do the care work. We advocate, we assess, we coordinate, and I think I'm getting ahead of myself on the slide here, so hold on. We have geriatric social workers on staff. Combined experience, over 40 or 50 years worth of experience to help our loved ones and our families navigate, all right, the whole elder care continuum. So that's our secret weapon. That's how we help our clients get enough hours so we can also help them get the best care possible. Now, our elder care coordinators, I like to explain it this way. Long-term care, in my book, consists of 5 factors. The actual hands-on care, very important. That's one part of it. That's the aid coming in the house. It's also about, though, ongoing assessments. We need to be aware of changes, increases, decreases, plateaus of what's going on with your loved one. And so do you. So there's always ongoing assessments. Coordinating the benefits and the providers. That's important. That is probably the biggest headache that we face for every single client going through the Medicaid process, because we have different providers, different MLTCs, different hours being approved. This is one of the most hardest parts of what we do. And very honestly, if you don't have us do it for you, you're going to have to do it yourself, because this has to get done for your loved one to get the best care possible. Crisis intervention. If there's a fall, if there's a hospitalization, if there's a rehab stay, my advocates are there to navigate the way. They're there to advocate. They're there to help get your loved one safely discharged as soon as possible so they can be back home again where we want them, all right? If there is an assisted living placement, they'll help with that. If there is a nursing home placement, we'll help with that. But the goal is to get them back home, all right? And the final part is advocacy. Again, to me, this is, go back to when you're growing up, right? This is the squeaky wheel getting the oil. It's through assertive advocacy where we're able to help coordinate and advocate and get the clients the most hours and the best care possible, all right? Now, finally, now that that's the current scenario laid out for you, that's the environment we're in, what exactly is the new Medicaid law and what's happening? Well, back in 2020, the governor signed a law basically changing eligibility for community-based Medicaid, all right? And that's what we're here to talk about tonight, because that change is coming, all right? Now, what actually is going to be impacted by this new law? What's going to be impacted? It's just community-based long-term care. It's not nursing facilities. It's not hospice. It's not nursing home Medicaid. It's home health care. It's private duty nursing. It's personal care services. It is what's called the assisted living program, and it's the consumer directed program where you choose your aid to help you. Now, the new law is changing things in that they are implementing a look back period, like I described regarding the nursing home scenario, right? The reality is that home care doesn't have a look back as of now, but when that new law is implemented, there will be a look back period. It is meant to be a 30-month look back period, half of the nursing homes, all right? It's going to be 2.5 years versus the 5 years. There will therefore be penalties, just like nursing home care, asset protection steps taken during the look back period, and then filing your community-based Medicaid application after the law is implemented, penalties, waiting periods. There will be higher care needs, as I shared before, that 3 ADL requirement with what's called physical maneuvering. Brand new concept. We have to wait for further clarification as to what that means. Of course, we can assume what it means, but we're waiting on the state to give more direction on it. So things are changing with community Medicaid. And when are they changing? Well, we are officially beginning this, according to New York State, January 1st of 2022. When this law was first signed, it was meant to begin October of 2020. Then they kicked it to January 1st of 21, then April 1st, then presumably to July 1st, all because of the pandemic. And that makes sense. They weren't going to implement this during the pandemic. But there is a general consensus that we should be clear of this, Lord willing, by the end of the year. And the declaration of the pandemic and public health emergency should be over. So therefore, New York has said January 1st, 2022 is when Medicaid will be changing for home care. So what does this mean? Any community-based Medicaid applications after January 1st will have a look-back period. And like I've said several times, that means penalties, that means waiting periods, all right? So now the look-back period is not automatically going to be 30 months. They're going to be phasing it in month by month, but there'll be an initial start date of October 1st. That was when the whole law was supposed to start to begin with. So if somebody applies for community-based Medicaid in January of 22, there will be a 14-month or 15-month look back to October. If they apply in February, it'll be 15 or 16 months. Every month you go by, it's one more month. Now, for those of you that don't have care needs right now, you should still get this asset protection work done. It's what we call an elder care protection plan. Why? Because if you get it done now, you start the 30-month clock. And therefore, you can go live your life, and Lord willing, you don't need care for at least 30 months for home care, or at least 60 months. So if you're not in a need for care now, still get the protection work done. It's what we call an elder care protection plan, all right? And yes, there's a webinar on it on the website. So the look back period will begin October 1, month by month, until it becomes a full 30 months. So what does this all mean? What's the title of the webinar all about? We've got months to protect and to apply because we are in the middle of what we're calling a window of opportunity. From today forward, as we've been doing for clients for the last several months, until January 1st of 2022, we can literally protect the house. We can protect your investment account. We can protect your cash value life insurance. We can implement a plan. And if you have the care needs, we can apply for community-based Medicaid before January 1st, and therefore no look back period, no penalties, no waiting periods. This is a unique period in time. I think I tell every single client I'm sitting with, this is the year to do this. If you came to me in 2022, we're going to have another problem, okay? And the goal is to avoid and minimize problems. So if you have a care need, 2 activities of daily living, you're around that spot, we can talk about it. The time to act is now, okay? I hope I'm making that clear. So when we're helping folks, it's what we call a long-term care plan, all right? That's generally what we're talking about. Our actual service, like I mentioned, is what's called the life care plan. But a long-term care plan in general has 3 goals in our book, all right? Not every attorney does it this way. This is how we do it. We have a legal perspective. We want to protect. We want to protect assets. We want to protect income. That's our legal goal, okay? Financially, right? This makes sense. We want to get the care paid for. That's what this is all about. On the care perspective, and again, this is what makes us unique. We want your loved one to get the best care possible, and we will do what we can to make that happen. Your loved one, your parent, your spouse is a whole person. They are not just a house that has to get protected. They are just not a home care bill that has to get paid by Medicaid. There are care needs that have to be worked on. There is an appropriate level of care that your loved one should receive. There is a quality of care that your loved one should receive. And that's what we pursue: the legal, the financial, and those care goals, okay? When a traditional or typical elder law firm, and I've got many friends and colleagues that do this type of work, they're focusing on the legal and the financial. Yes, they'll do that right power of attorney. Yes, they'll do the irrevocable trust. Yes, they'll do the Medicaid work to get the bills paid for home care. But like I shared before, the advocacy, the coordination, the crisis intervention, the assessing, those aspects of long-term care are up to the family, okay? And to me, that's no way to go through this blindly. This may actually be the first time you're jumping into the long-term care system. Do you really want to have to reinvent the wheel and learn everything on your own? Why not let experienced advocates and elder care attorneys that do this every day guide the family through the whole process? So when we come on board, again, with our life care planning service, we will address the legal, the financial, and the care. We will do all we can to protect the assets and the income. We will do all we can to help Medicaid pay those home care bills, and we will do all we can to help your loved one get the best care possible, all right? What does this all mean? It means take action now. Again, if you have a care need, now's the time to talk to us, all right? We offer free consultations. Get the ball rolling. There will be an onslaught of applications come the end of the year. You do not want your 5 or 6 month window of time to be pushed out to 7, 8, 9 months if that were to happen, because you've got thousands of people applying before the deadline kicks in, okay? So if you have the care need, get the ball rolling, stay in control of the situation, okay? If you don't have the care need, the time is now to do the asset protection, what we call, again, an elder care protection plan. Get that irrevocable trust in place. Get the modified power of attorney in place, the last will and testament, the healthcare proxy, the living will. And when we do this work, we don't leave you alone, all right? We stay on board for a year at a time. As much as you want us to be involved, we're involved. You have changes to make, we'll do it. You have questions, we'll answer every single one multiple times. We are here to help the family through their elder care journey, all right? I know I spoke fast. If you have questions, I'm here to help. I'm here to answer. I will check the Q&A in the chat. Enter your questions now if you have any. If we can help you, give the office a call, all right? 631-424-2800. Email me directly, Brian with an I, as I tell people the right way, at tullyelderlaw.com, TULLYELDER law.com. Sometimes I've spelt .com, and I think my kids laugh at me when I do that. But Brian at tullyelderlaw.com, let me know what's going on. I can get you in touch with my client relations manager, our admins that can help get you in here, or we can Zoom even if you'd like. Some folks are still doing Zoom consults. We're here to help. Thank you very much. Let's see if we have any questions. Dun, dun, dun. Okay. Oh, great question. I think I'd love to see this happen. Will MLTCs eventually be going away? MLTCs are the managed long-term care agencies that were implemented about 6 or 7 years ago. Again, managed care, think old school HMO. I've heard rumors, I've read that the goal is to get rid of the MLTCs, but I've not seen a replacement. I haven't seen options or alternatives, so I don't know yet, okay? Do I think they'll eventually be gone? Perhaps, all right? We don't have any details. Another question. What happens if a person has poor judgment due to mental capacity issues? Again, another good one, Karen. So the question is, what if there are capacity issues, mental capacity issues versus physical issues? If you caught, and Karen did, that long-term care these days is all about the physical activities of daily living. What about those with dementia and supervision needs and wandering issues? Gratefully, there is a silver lining, if you will, on the new law that's coming out. And on one hand, they're increasing the physical requirement of physical maneuvering with 3 ADLs, but they are, again, gratefully, allowing for a cognitive decline, or I should call it an actual diagnosis, a dementia diagnosis or Alzheimer's diagnosis to trigger the care. First time ever that's happening in New York, and I applaud them for actually finally introducing this. So if there's a diagnosis, you no longer have to demonstrate physical need, but rather you have to demonstrate supervision need. And the threshold is much lower. Sometimes I say to clients, you can have a loved one faced with cognitive decline, but they're good physically. Or you can have physical decline, but they're good cognitively. But rarely, but sometimes you can have a loved one with both, the cognitive decline and the physical decline. But again, one good part of the new law coming out is there will be that exception for a diagnosis. Okay. Other questions? Okay, power of attorney. So yes, we do have the new power of attorney form. We've been modifying it to our taste, including the provisions that we want our clients to have. The law actually takes effect June 13th, which is Sunday, but we'll be using it as of Monday, all right? Amy Latuga, who's in charge of planning for our office, she's an absolute fantastic attorney and person, has been building this for us, and we'll be sitting down with all the attorneys in the office over the next day or two to just kind of review it all, okay? But yes, we'll be up and ready with the new power of attorney sooner rather than later, okay? Medicaid, 5 to 6 months for the actual application process. Can it go faster? The answer is yes. If you recall, I broke it down into 3 segments. So you have to get us the documentation, we have to complete the application, we've got to submit the application, then we've got the care assessments. There is something called immediate need. If there is no care in place, the state allows us to go through an avenue called immediate need versus the MLTC avenue. Immediate need, believe it or not, and this is the state, still takes 3 to 4 months. But it is faster than the MLTC route. So that is an avenue. It's possible if there's no care in place. Another question popped up. I saw it. Where to go? Okay, good. Thank you, Linda. No, the changes that we're talking about community-based Medicaid are only in New York. The 5-year look back and most of the nursing home rules, those are federal in nature. Home care has been based up, each state has what's called a waiver to do their own type of home care program. So this aspect of creating and implementing a look back period for home care is just New York, not New Jersey. New Jersey already has its complications, all right? I don't practice in New Jersey, so if you need an attorney over there, let me know and I'll find you one. Oh boy, all right. A real practical problem is the other point. Mr. Anonymous is stating that Medicaid approved my mom for 24/7, but the agencies will not give me 24/7. What do I do? That is a real practical issue. I believe it is entirely related to the pandemic, and it is related to, in my opinion, extended unemployment benefits, perhaps. What we're seeing is a shortage of aides. And last year we had a problem where the aides were perhaps had the illness themselves and they couldn't work, or they were quarantined and they weren't able to work. So we went through that with the pandemic. Now, people are healthier. We have less quarantine, less infections, but we're still having a shortage of aides and we don't know why. So that's probably what the issue is. And you're not the only person dealing with it. It is a sad reality of right now that we're having a hard time getting our clients the care that's been awarded and getting the aides in the house. We're doing pretty good. We not that we have, insider knowledge or so forth, but we have relationships and we're fighting and we're pushing for care. I can't guarantee an aid for anybody, but we're pushing and advocating for care. But unfortunately, again, sir, that's what you're looking at. Okay, we're hoping it's going to come to an end soon. How long do you think it will now take to fully be approved for community Medicaid once the new law? Good question. So once the new law is implemented, I think it's going to be a mess for a little while. Many of my colleagues believe the same. we don't know what's going to happen. We don't know if they're going to extend it again. I don't think so. I think January 1 is it. We don't know exactly, because there are other changes happening. They're talking about bringing in a physician to do an assessment. They're talking about a uniform assessment to be utilized, a tool to be utilized. That may take more time to create and implement. So we don't exactly know yet. We're just going to have to wait and see and try our darndest. Not tooting our own horn here, but if there ever was a reason to go with an experienced attorney, an elder care law firm that has advocates, that knows their way around the system, now's the time. We do have clients that try the Medicaid route themselves. If it is super simplistic, go ahead. But you got to be careful. You don't know what you don't know. When it comes to Medicaid, you've got firms like ours. I've been doing this for 23 years. You do have a good handful of attorneys that know exactly what they're doing. We focus more on the care. You then have attorneys that, what I call part-time attorneys, meaning they'll do divorce, they'll do criminal law, they'll do contracts, they'll do real estate, and they do elder law. Go ahead. You can use an attorney like that. That's fine. Be careful with the experience level. Be careful with the advocacy that they can offer. Just be mindful of who you're hiring. All right. Again, there are some attorneys that can absolutely get an application approved like that. Then you have non-attorneys even doing it. To me, Medicaid work is legal work. You're dealing with rules, regulations, statutes. You're talking about people's money, people's assets, and the application of laws to that money and assets and their income. That is practicing law. So to me, an attorney should be doing this type of work. Okay. That is my humble opinion. All right. That is it on the questions. So I lost my cloud here. Where did we go? Where'd you go? I lost my camera. There we go. So again, thank you for joining us. If you had a question and I missed it, feel free to email me directly and I can help you with that. Otherwise, thank you. We look forward to next week. I don't know the topic. Next week is actually going to be our Q&A webinar. We're implementing and starting a monthly Q&A. So you're registered just like these webinars. You can hit me with whatever questions you have in advance, or we'll be doing a Q&A box just like this. It'll be free flowing. There'll be any topics you want to talk about in regards to elder care and aging and asset protection. All right. So again, thank you. And we'll see you then. Bye-bye. Where are we here? Good. All right. Bye-bye. Have a good night.